Supreme Court judges held a day-long meeting on Sunday to finalize their judgment on two petitions seeking to annul President Uhuru Kenyatta's victory for the second time in 3 months. The judges chose the Supreme Court building to deliberate the judgment that they will make Monday, with President Kenyatta waiting to know which direction their determination will take and the subsequent ramifications. As the judges worked to beat the clock, the man at the center of the petition chose to visit and have lunch with his mentor in Nakuru. Moi. President Kenyatta, on his Twitter handle, revealed that he had paid a visit to former President Daniel Moi at his Kabarak home in Nakuru. However, no details of the meeting, which was also attended by Baringo Senator Gideon Moi, were forthcoming. In their closing arguments on Thursday, the petitioners through lawyer Julie Soweto told the 6 judges that they should not fear, but uphold the rule of law and constitutionalism by nullifying the poll once again. She told the court that by doing so, the judges would be shutting the door unto darkness. According to Ms. Soweto, by validating an illegal election, the court would be dividing Kenyans more, if they are not already. However, President Kenyatta's lawyer Fred Ngasha urged the court to dismiss the petition, stating that there would be lack of a constitutional order by invalidating the poll outcome. He urged Chief Justice David Maraga, DCJ Philomena Mwilu, Jack Dinajwang, Smokin Wanjula, Njoki Ndungu and Isaac Lenaola to look at the common good of the nation. Among the issues the 6 Supreme Court judges were to grapple with is whether the voter turnout affected the outcome of the presidential poll. Cast votes. The petitioners argued that the voter turnout was so low such that it cannot be said that those who came out to cast their votes represented the whole country. The Independent Electoral and Boundaries Commission and President Kenyatta also argued that to vote is a choice and those who turned out to cast their votes cannot be punished because others declined to express theirs. Ms. Soweto also argued that the failure to hold elections in some 3,635 polling stations representing 1,770,475 voters was fatal. This, she attributed to violence and intimidation, adding that the information had been captured in various reports by reputable organizations including government-owned Kenya National Commission on Human Rights. Mr. Ngasha, however, said, "You cannot vitiate an election on account of violence, which has been instigated to deny a majority their will to vote." Ms. Soweto also questioned the impartiality of the EBC and its chairman Wafula Chebukati. Violence. She said the commission lacked independence, stating that there was violence externally and internally, which affected the commission's work. This court cannot avoid the reality before its eyes. EBC is under the control of the third respondent, President Kenyatta. Their pleadings and responses are similar. The chairman was never independent and evidence will show that he worked to please political leaders, she said. Another issue the judges were to look at is who was eligible to contest in the repeat poll on October 26. The petitioners have argued that the move by Raila Odinga to abandon the race meant that the poll was voided. They also questioned the inclusion of Mr. Cyrus Jirongo's name on the last minute. Mr. Ngasha and Debs Kamakarori argued that the commission made all its decisions guided by the law and the court. Mr. Karori said the decision to include other candidates was based on the High Court ruling.